And that's how the police officers make contact with you, correct?
Yes, ma'am.
Okay, and so in the 2024 case, you were also
substance penalty group 1 to 4 grams, and count 2, you're charged with unlawful possession of a firearm by a felon. Those are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right, and you can present whatever evidence you wish to present to the court.
Yes, Your Honor, you absolutely will. I did want to put, and this is not part of
Well, does he want to waive the PSI, or does he want a
He
PSI?
wants, go ahead, waive the PSI.
Yes. Yes, Your Honor. I wanted to waive the PSI.
All right, so then what will end up happening if I'll reset this at a date your attorney deems appropriate for him to have witnesses or whatever evidence he wants to present to the court. Do you understand?
going to hand it over to me.
All right, thank you. So if you'll announce for the record, please.
Okay.
All right, defense has informed me on this case he has no witnesses. The state is opposed to the defendant's application. Do both parties need a couple of minutes?
Yes, Judge, I guess it's review. I was going to offer the criminal history.
Yes.
That's what looks like.
Okay. All right, defense, any witnesses or is just argument?
Just argument, Your Honor.
All right, you may proceed.
This
Yes,
case
ma'am.
opens with a pattern, and patterns matter in court. 2 separate incidents, 2 times behind the wheel, 2 times officers make contact, and both times the defendant admits he was asleep. But this is not just a story about falling asleep at the wheel. What you're about to see is a courtroom weighing addiction against accountability, rehabilitation against public safety, and sympathy against a criminal history that keeps repeating itself. On one side, a man claiming real change after treatment. On the other, a record involving narcotics, firearms, and multiple felony convictions. The judge here isn't just deciding guilt, she's deciding risk. Risk to the public, risk to children, risk of giving someone one last chance. As you watch this unfold, ask yourself, when does compassion stop and when does responsibility take over? Because by the end of this hearing, the decision won't be easy and the consequences are life-altering.
As I look at his history, he's got an issue, and all of it seems to circle around drugs. The court did the thing I think that's helping him the most, regardless of the sentence today, and that was he needed treatment. And he got treatment, and he went to lifetime. I think it was 45 days there. And, Your Honor, since that time, my understanding, the reason he was put back in jail was because he was having some issues with his bail bondsman. And the conclusion, and the only conclusion I can reach about him, it's an excellent one, and that is the fact that treatment so far took on him. And we would submit to the court based on that this court consider probation and all the things that this court can use to make sure he performs well, or in the alternative, this is a cap, sentence him at the lower end of the cap. And once again, this is because, from what I can tell, lifetime took. And I know he's got a lot more work to keep it working. He's going to have a day-in-day life where you fight drugs, and there's a program out for them. He needs to make a meeting every day for the next 90 days, regardless if he's in jail or out of jail. Thank you, Your Honor.
Your Honor, you're asking that you deny the application to 8 years in prison. I think that the defendant's record is pretty clear that he had been given a chance previously for treatment, and not only does he keep possessing narcotics and controlled substances, but with felony convictions, he's also possessing firearms. And so, as part of the plea deal, we did waive the habitual enhancement, and what was listed on the indictment is a 2017 conviction for possession with intent to deliver PG1 less than 1 gram but in a drug-free zone. And then the second enhancement was for a 2020 felon in possession. And so I think there are programs to address drug issues, but there's no program to address somebody that just is committed to possessing firearms. For that reason, we're applicating.
All right, thank you. Is there anything you wish to say?
Yes, ma'am.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
This is the turning point of the hearing. The defense frames the defendant's history as drug-driven behavior, emphasizing inpatient treatment and arguing that it took. But listen closely to the prosecution's response, because legally, this matters. The state isn't just talking about drugs, they're talking about drugs plus firearms, and that combination changes everything. While drug courts and treatment programs exist to address addiction, there is no program that excuses a felon possessing a weapon. Enhancements were waived here, meaning the defendant avoided even harsher penalties, but the state is still pushing for serious prison time. This is the legal tension, treatment success versus repeated dangerous conduct, and it raises a critical question for viewers. Should past rehabilitation outweigh repeated violations, or does history eventually speak louder than hope?
Johnny Richard Gonzalez.
All right. What would you like to say?
I'd like to say that lifetime recovery helped me a lot because I didn't know how to deal with none of my past issues. I was self-medicating, and with lifetime recovery, I learned how to cope. I learned how to ground myself and process the situation, and now I know how to cope with it. And I would like to continue my life with the tools that I learned at lifetime.
All right. State any questions?
So, Mr. Gonzalez, back in 2024, when you picked this case up, and then you have the other case that was from 2025, you're aware of those two charges that you're here for today, correct? Okay. And so you would agree with me that the facts and circumstances in both of the cases are kind of similar, correct?
Yes.
And that you were operating a motor vehicle both times, is that correct?
Yes.
And then both times you were asleep at the wheel, is that correct?
This is where the courtroom shifts from legal arguments to human consequences. The defendant speaks about addiction, grief, homelessness, and learning coping mechanisms through treatment. The judge presses further, asking about family conflict, a disputed will, and children who have lived through the instability of addiction. And notice how the court balances empathy with skepticism. Acknowledging trauma does not erase responsibility. The judge is evaluating credibility here, whether these lessons will hold once the structure of court supervision disappears. The discussion about daily meetings, supervision around minors, and long-term accountability shows how seriously the court views relapse risk. This moment forces a hard audience question. When someone explains why they broke the law, does that explanation justify another chance, or simply explain the pattern?
You were asleep at the wheel, is that correct?
Yes.
And that's how the police officers make contact with you, correct?
Yes, ma'am.
Okay, and so in the 2024 case, you were also, well, I guess what was going on in your life that you were asleep at the wheel of a motor vehicle?
I was going on with family issues, and so I was self-medicating, and I was working as well. So I just didn't know how to cope with none of that stuff.
And when you say self-medicating, what were you using to do that?
I was using methamphetamines so I could still be able to work.
And then in the 2024 case, in that case, you were also in possession of a floodlight, is that correct? The motor vehicle?
Yes.
Okay. And when did you complete lifetime recovery? Was that a part of your bond?
It was part of a pretrial. And I don't remember the date I completed.
And was that inpatient or outpatient?
It was inpatient.
Okay. And do you recall how many days that was?
It was 45 days.
Okay. And then just regarding your history, and you two have prior history of drugs and also possessing a firearm, correct?
Yes, ma'am.
And
Just one question.
Mhm.
You understand for the rest of your life, especially for the first 2.5 years, you need to make a meeting every day, sometimes more than one day.
Yes, sir.
That's the only way you know you can make it.
Sir.
Thank you. Pass the witness, Sean.
All right, I have a few questions. Any objection?
No.
Okay. So, gang affiliation, any?
No, ma'am.
All right, so you said you were going through things. What things were you going through that you continue to use?
I was going through my father had just passed recently, and so while he was sick, everybody was fighting over the property, and I was not. My brother does not let me stay there because I was self-medicating and stuff. But everyone's arguing over the property and stuff, and just
Which people do when there's no will.
yeah.
That's why everybody should have one.
Mhm. And so when my father passed, my brother ended up making a will and put everything in his name. So I was in the streets, so I was just,
Well, that's sort of a crime, maybe. I don't know.
yeah.
Somebody just can't make up a will after somebody passes and sign off on it.
So like, I was
But it's been to happen.
trying to survive, but I didn't know how to cope with none of that stuff before. I didn't know how to ground myself and process it and use my brain. So, but I learned a lot when I was in Lifetime.
What did you learn at Lifetime?
I learned how to slow down and process the situation, and instead of taking off to the races, no, I ground myself and find coping skills as working out or the Bible and working, just staying busy and doing meetings and just speaking about my problems.
Do you have any children?
Yes, ma'am.
In the end, the court delivers a decision that walks a tightrope. 8 years of deferred adjudication, strict supervision, mandatory treatment, firearm prohibition, and severe restrictions involving minors. This is not leniency, it's conditional mercy. One violation, and the defendant faces up to 10 years in prison. The judge makes it clear every future decision must be filtered through one question: could this send me back to prison? This ruling reflects a broader legal philosophy. Rehabilitation is possible, but only with constant accountability. Deferred adjudication isn't a reward, it's a test, and the outcome now rests entirely on the defendant's choices.
Education? Absolutely not. But I will give you deferred adjudication. And what I can tell you about deferred adjudication, the state is asking that your punishment be capped at 8 years. If you are unsuccessful at deferred adjudication, you will be looking at the full range of punishment. That's 10 years, right? But I'm telling you, with deferred adjudication, you're going into inpatient treatment. You're either doing inpatient treatment or felony drug court. Felony drug court, they may or may not be able to accept you. We can see. But if felony drug court doesn't accept you, inpatient treatment. There's no coming back to me saying, Judge, it's taking too long for inpatient treatment, because that's where you would be going. Or this is your other option. I will find you guilty and I will sentence you to 5 years in the prison. Which do you prefer?
Inpatient.
All right. Then this is what the court will do. Counts 1 and count 2 will run concurrently. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. And state, I know you were opposed, but does anyone want to give their opinions on the length of deferred adjudication?
I'll defer to the court.
I would defer to the court too. I think you're using your wisdom to decide where you're going. And I agree. If this guy needs to be in a place, from my life's perspective, that he has to live with this every day. In the words he's got to constantly say is go to a meeting, go to a meeting, go to a meeting. If you feel anything in your brain, any new thing or old thing, drag your butt to a meeting. That is one thing you can always simply do.
All right. So there is to be 8 years deferred adjudication, proof of employment within 30 days of release, There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. That could potentially change. It's going to 100% depend on you, because you should not be around any children, unless your children, unless you are supervised in a controlled environment until I deem that you are clean and sober. There's to be no residing in households with minors. I want a referral to felony drug court in custody. And of course, Ms. Abrams, this felony drug court accepts him. I would prefer for him to be in that program. There's a $2,000 fine that will be probated. All right. So there's $180 restitution to DPS with reference number. You're not allowed to carry a weapon. You're a felon. You understand? Is there anything else that you need from the court so that you can be successful on this probation? All right. So here's the thing. From here on out, everything that you do, you need to ask yourself, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. And if you don't want to do it for yourself, then do it for your children. You should always do it for yourself. But if you don't think you're worth it, ask yourself, are your children worth it? You understand? And that whole conflict you have with your relatives, when you